Yes.
Let them know we're live.
I'm waiting for the thing to go across. Chair Smith, you're live. Chair Smith, you're live.
Okay, he knows.
He does?
Can you mute yourself?
Yeah, now.
Hey, sorry about that, guys. All right, a little technical difficulty here. Well, welcome to Judicial Proceedings Committee. Today's Thursday, March 18th. We have 9 bills on the docket, and we'll start off with Delegate Fraser Hidalgo with Senate Bill 250. We'll then go to 268, 271, 347, 356, 366, 483, 562, and 647. So with that, we will start off with Delegate Fraser Hidalgo with House Bill 250. Delegate, the floor is yours.
Thank you, Mr. Chairman. Thank you, members of JPR. I appreciate your time today. I'm here introducing House Bill 250. House Bill 250 passed out of the House last year, and then unfortunately was one of those that just didn't make it out because of COVID last year. We passed it out early this year. It's a pretty simple bill. It essentially looks at a Class F trucks, which are the big tractor trailers, and usually they it just changes the amount of times that they are inspected from 25,000 miles to 35,000 miles, the time that they're annually inspected. And the reason for that is because the trucks are much safer today than they used to be. And this only includes trucks that are less than 5 years old only. And secondly, it takes Class E trucks, which are also trucks and dump trucks, and takes that from 25,000 miles to 50,000 miles if they are electric trucks in nature. So if they're electric trucks, they get a longer period of time. Again, I want to stress that it has to be within 5 years also. So if the trucks are over 5 years old, it goes back to defaults to the original inspection time. The trucks today are much safer with lane keep assist and auto braking and all kinds of technical, I guess, brakes and steering mechanisms and all kinds of ways to make the vehicle safer. So this just elongates that. Maryland is one of the few, I think the only state in the country that actually has as many inspections as it does. So with that, I ask for any questions and a favorable report.
Excellent. Thank you, Delegate. And with that, that will end the hearing for House Bill 250. Nice sash, by the way. The members over here had to relinquish them so they could go over to the House. I'm trying to score one for my daughter. So if you help brother out, we'll get on it. All right. Well, thanks. Good to see you, man.
Thank you.
Have a good one. All right. Next.
Bye-bye.
Thanks. Have a good one. We'll go to Delegate Grammer with House Bill 268. Delegate Grammer, the floor is yours.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 268. House Bill 268 creates an exception to the spousal privilege that prevents invocation of the privilege in the case of a marriage after the alleged crime. Kiera Bannister informed police about the confession of Daryl Wilson to the murder of Crystal Anderson. She also informed police that she witnessed the selling of Anderson's possessions after Anderson's disappearance. Wilson and his accomplice were subsequently indicted for murder. While held in detention, Wilson made several phone calls between December 2016 and February 2017 to discuss his conspiracy to marry Bannister in order to prevent her from testifying. Wilson subsequently married Bannister on February 9th via a conference call. Wilson connected from the detention center. Bannister was on a work break. The pastor who married them called him from New Jersey. Intimidating witnesses into sham marriages with the purpose of disqualifying their testimony via the spousal privilege is a known tactic among criminal networks. House Bill 268 closes this loophole by creating an exception to the spousal privilege that disallows the invocation of the spousal privilege in the case where the defendant and the partner were married after the crime in question. The inability to procure witnesses is among the top reasons that we fail to put violent offenders behind bars, and we help deter witness intimidation with this bill. With that, I'll say thank you for the hearing for House Bill 268. I'm happy to discuss questions, and I'd ask for a favorable report.
Excellent. Thank you, Delegate Grammer. Good to see you.
You as well.
With that, that'll conclude the hearing for House Bill 268.
I think
Senator,
you have a question from Senator Sidnor.
Senator said, yeah, we try to keep our questions to a minimum in this format, but let's go ahead. We got voting to do, and we got a long list to get through. So go ahead. Yes, go ahead, Senator Sidnor.
Well, thank you. Just the question I had is in reading lines 9 through 11, it seems as if any crime that's committed after marriage is, I mean, the way this language is essentially just gets rid of the spousal privilege.
Well, it only in the cases where the alleged crime happened, it would essentially close the loophole that allows for the invocation of the privilege in between the time of the marriage and the crime itself. So in other words, you would have to have a scenario where a couple planned a marriage, one of the couple was allegedly committed a crime, the couple decided to continue with the marriage, and the other person in the marriage just happened to be the witness that reported the crime. Remember, in the example case, Ms. Bannister, she was the one that actually reported the crime. So what frequently happens, and what wasn't pointed out in the testimony, is that the defendant was in a detention center, and that's how hypothetically he could read the statute and figure out the loophole and subsequently romance someone from the detention center. But that's just not the case here. What's actually happening is attorneys say, like, look, if there's any way you can get married to this witness, we can disqualify her from using testimony. And that's what's happening. Criminal networks exploit this loophole to essentially pressure what is predominantly females into false marriages.
Thank you.
Thank you.
Senator gets a question because it's his birthday. Happy birthday, Senator Sidnor. All
Thanks,
right.
and good to see everybody.
Hey, thanks, Delegate Grammer. Have a good one. All right, with that concludes the hearing for House Bill 268. We'll now move on to House Bill 271 with Delegate Ebersol. I just tried to unmute you here.
Got it.
There you go. Got it.
Thank you very much, Mr. Chair and senators of the Judicial Proceedings Committee. This is my first time in front of you all. I appreciate the opportunity to offer testimony on HB 271. It would formally authorize law enforcement diversion programs in Maryland and require the Governor's Office of Crime Control and Prevention to collect data and release annual reports on these programs. It would benefit jurisdictions that already have the program, and for jurisdictions that may want to utilize one in the future, it would not require jurisdictions to adopt the program. In law enforcement diversion programs, police officers exercise discretionary authority at the point of contact to divert individuals to a community-based harm reduction intervention for law violations driven by an unmet behavioral health need. In lieu of the normal criminal justice cycle, booking, detention, prosecution, conviction, and incarceration, individuals are instead referred into a case management program where the individual receives a wide range of support services rather than entering the prison pipeline, often including transitional and permanent housing and or drug treatment. Prosecutors and police officers work closely with managers to ensure that all contacts with diversion program participants going forward, including new criminal prosecutions for other offenses, they're coordinated with a service plan for the participant to maximize the opportunity to achieve behavioral change, which is a goal of all of ours when people are making mistakes. This bill is an important step in bolstering existing programs, understanding the effectiveness of those programs, encouraging new programs in other jurisdictions, and most importantly, reducing the number of people in the criminal justice system. I respectfully request a favorable report on HB 271. A similar bill was passed last year by the Judiciary Committee in the House and arrived a little late for you all to take a good look at it. I appreciate you doing that this year.
Most certainly will. Thank you very much, Delegate Ebersol. And with that, we'll conclude the hearing for House Bill 271. Thanks a lot.
Thank
Good to see
you. Yeah, likewise.
All right, we'll move on to House Bill 347 with Delegate Shetty. You're up.
Thank you, Chair Smith, Vice Chair Wallstreicher, members of the Judicial Proceedings Committee, Delegate Shetty here. Thank you so much for the opportunity to testify today in support of HB 347. This is a bill that will strengthen our laws that protect seniors and vulnerable adults from undue influence. This bill passed the House Judiciary Committee unanimously, and it passed the House of Delegates on a consent calendar vote of 131-4. As you might recall, undue influence is a legal doctrine that dates back to a common law case in 1617. And although our understanding of undue influence has evolved, our laws across the country and here in Maryland have not kept up. These cases are incredibly difficult to prove, in part because they often occur behind closed doors and without witnesses. There is a lack of a clear definition of what undue influence is under the law, and it is often complicated by the assumption that mental capacity and undue influence are linked, which is not always the case. For example, one could be of sound mind and still fall prey to undue influence due to other factors, such as the relationship between the influencer and the victim. This bill will strengthen our criminal code as it pertains to the definition of undue influence of a vulnerable adult, specifically as it relates to the transfer of property. The idea behind this bill came by way of a constituent, Claudia. Very sadly, prior to Claudia's uncle's passing, he was defrauded by their financial advisor, who was able to convince her uncle to place the advisor into the uncle's will as the sole beneficiary. It is important to note that while there was a civil suit that was settled, a criminal case was not pursued, in part because the standard in Maryland is so difficult to prove that cases like these are rarely successful. HB 347 adopts language that was first enacted in California in 2014 after a multi-year study on how to protect seniors from financial exploitation via undue influence. HB 347 provides a clear definition of undue influence and bases it on detailed recommendations by psychologists, sociologists, criminologists, victimologists, legal experts, and courts that have focused on the following 4 things. Number 1, victim characteristics that contribute to vulnerability. Number 2, the power dynamic between the influencer and the victim. Number 3, improper actions or tactics taken by the influencer. And number 4, unfair, improper, unnatural, or unethical transactions or outcomes. Each of these components are addressed in this bill. The bill defines undue influence as, quote, excessive persuasion that causes a vulnerable adult or an individual at least 68 years old to act or refrain from acting by overcoming that person's free will and that results in inequity. It then defines in section G what the court shall consider when determining whether undue influence was used to obtain property. It defines characteristics that would cause the victim to be vulnerable, whether the defendant knew or should have known that the alleged victim's vulnerability, the defendant's apparent authority, various tactics that could be used to engage in undue influence, as well as the inequity that results from. Due in part to our aging baby boomers, between 2000 and 2010, Marylanders over the age of 68 grew approximately 6,862 per year, while between 2010 and 2018, that number skyrocketed to over 21,815 per year. It is imperative that we examine and improve this section of our code, as the number of potentially impacted individuals are growing at a very rapid rate. We've also seen a significant rise in financial crimes, particularly targeted at seniors and other vulnerable adults during the course of the pandemic. Just last month, just in December 2020, the U.S. Attorney's Office for the District of Maryland seized 2 domain names which purported to be the websites of actual biotech companies developing treatments for COVID-19. In reality, these websites were used to collect personal information of individuals in order to use the information for fraud and phishing attacks, among other forms of exploitation. It is imperative that we address undue influence in Maryland. This bill is identical to a bill, HB 320, that passed the House of Delegates unanimously last year. It was cross-filed with the Vice Chair's bill, SB 702. While that bill was referred to this committee last year, we didn't have enough time for your careful consideration prior to the early adjournment. I respectfully request a favorable report. Thank you. And happy birthday to Senator Sidnor.
Oh, bonus points. All right. Thank you, Delegate Shetty. With that will conclude the hearing for House Bill 347. Good to see you. And I'm frozen. All right, there you go. I'm unfrozen now. All right, so with that, we'll move on to House Bill 356 with Delegate Chi. Delegate Chi, you're up. Good to see you.
Good to see you. Thank you, Chairman Smith. And I want to give a special shout out to Senator Lee. It's my first visit to Judiciary Committee, Judicial Proceedings Committee. So thank you for the opportunity. For the record, I'm Delegate Lily Chi, here to present HB 356, which is about business filing fees. I just want to say that this bill passed the House twice in a row last year with bipartisan support. It's a very simple bill that requires the State Department of Assessment and Taxation to first assess Maryland's competitiveness in how we collect business annual filing fees. Because currently every business, most every business, except for sole proprietors and family farms, for example, have to annually file with SDED and pay $300 annual filing fee. And the second thing it does is to require SDED to recommend a new filing fee structure that in terms of frequency of filing and amount we charge to make Maryland more competitive. And the reasons for this bill were very simple. When I was working in economic development in Montgomery County, I got an earful of complaints from mostly small businesses that said, this is such a nuisance and a burden. Why should I have to file annually and pay $300 just for the privilege of paying taxes to Maryland? You know, I'm already paying taxes, and this is an extra burden that we don't need. Even when I'm not turning a revenue or profit, I still have to file this filing fee. So this is really about competitiveness. And the other thing is many of my colleagues, both Senate and House side, over the past few years, on numerous attempts have been trying to scale back this burden, make it more fair, making ourselves more competitive. But almost none of these bills passed because of the fiscal note. So our bill this time is very simple, just to say, SDED, please take a look at how do we come up with a more competitive and a fair structure in comparison with our 6 neighboring jurisdictions without being presumptive, without saying, you know, we should scale back according to employee size and revenue size and what have you. So this is essentially what this bill does. And SDED is excited to do the job. They said it's overdue. They would love to just, you know, get on with this analysis and give us the information before we come up with smart policies on this. And of course, there's no fiscal note. And with that, I would urge a favorable report. Thank you very much.
Excellent. Thank you very much, Delegate. And with that, that'll conclude the hearing for House Bill 356. Good to see you. Come to JPR more often, you know, it's good stuff.
Thank you. I will.
Yeah. All right. Have a good day.
Thank you.
Next, we'll move on to, is Delegate Cardin here? He's next on the list, but if not, we'll move on to Delegate Turner. I see Delegate Turner's here. So Delegate Turner, we'll move on to House Bill 483. Good to see you. Welcome. The floor, I'll ask to unmute you here. And here we go. I'll try one more time here. Is anything popping up to unmute? Nope. Maybe Vicky, can you try to unmute her, or can you unmute her?
We're trying here at this end also.
Okay.
It's not. There she goes.
Oh,
She's
I
good.
use mine.
excellent.
Thank you. And also, this is my first visit to this committee. I want to have a shout out, can I, to Senator Sidnor, happy birthday. And to my former seatmate, Michael Jackson, y'all took him from me. He used to sit next to me in the House. Okay, so for the record, I am Delegate Veronica Turner, and this bill is before you is HB 1384, towing and removal of vehicles from parking lots, reclamation hours. This bill passed out of Economic Matters and the House almost unanimously last year and this year. This bill is to protect the tow truck drivers from being rising level of violence that occur against them under the cover of the night when people are angry and intoxicated. It is important to note that this bill reads at a minimum from 6 a.m. to 12 midnight. The companies can remain open for 24 hours at their discretion, as well as reopening to release a car can certainly do that. This addressed the issue of companies not wanting to shut down or people who may need to get their cars back immediately. This bill does not ask for anything that the governor sponsored. Tow truck companies don't already have. You must pick up your car between 9 and 5 when the governor has you towed. If you park in the president of the senator's space, you will not be able to get your car until 9 a.m. This bill simply allows tow truck companies who has experienced dangerous situations, such as the murder of Tariq Butler, who was killed last year at the RPM towing in College Park in the early morning hours around 1 to 2 a.m. to be able to close between midnight and 6 a.m. I urge a favorable report on HB 483, and I thank you very much for hearing me.
Excellent. Thank you very much, Delegate Turner. And with that, that will conclude the hearing for House Bill 483. We're getting a lot of love from the committee members, so thanks a lot for being here, and we'll see you soon. Have a good one. All right, next, Delegate Cardin is back, so is here. So we'll go with Delegate Cardin with House Bill 366. Delegate Cardin, you're up.
Thank you very much, Mr. Chair, members of the committee. John Cardin for the record on House Bill 366. This is a bill that passed unanimously out of the House. It just allows, it's a clarification of the law that allows district court judges to be able to convert a warrant to a summons as appropriate and as justice requires. You have a similar bill, although not technical cross-file, in Delegate or Senator Waldstreicher, and I am happy if we want to make them look almost identical, even though they're technically are not cross files.
Excellent. Thank you very much, Delegate Cardin. And with that, that will conclude the hearing for House Bill 366. Thank you very much. Good to see you. The beauty of Zoom, testifying from your car. There you go. All right. Awesome.
Very good. Thank you.
Stay safe. Have a good one. All right. Now we'll go on to, I have a list here for House Bill 647. Do we have that? There we go. See, we'll go with, okay, there you are. You're with SDAT. Mr. Higgs, you're up.
Good afternoon. My name is Michael Higgs, Director of Maryland Department of Assessments and Taxation, and I'm here to talk about House Bill 647. This bill would repeal the fee charged by SDAT that companies pay for submitting documents to go out of business. When a company registers with the state to go in business, we have excellent data on who all those companies are. But when companies go out of business, we rely on them letting us know that they decided to go out of business. Right now, there's a $100 fee for telling us that they've gone out of business. A lot of companies say, well, I've wrapped up my business. What do I need to deal with that for? So they just walk away from it. That leaves a lot of unintended consequences that spill out from that. From our department continuing to issue assessments on their personal property, to the county governments trying to collect on what end up being uncollectible personal property tax bills. The state ends up with very poor data on how many companies are actually in business in Maryland from time to time. So really this fee stands as a way of getting in the way of good data, of entrepreneurism, of efficient government action. So in spite of the fact that this has a fiscal note of almost $800,000 annually, it is our opinion that that it is a very good use of state resources to eliminate this fee and instead encourage entrepreneurism, allowing people to take another shot at starting up their business. And also getting much better data and helping the county governments function a little more efficiently. We have support from MACO on this, and it passed the House unanimously. If anyone has any questions, I'm happy to help.
Excellent. Thank you very much, Mr. Higgs. And seeing no questions with that, that'll complete the testimony and the hearing for House Bill 647. Thank you very much. All right, so we have one more bill, which is House Bill 562. Vice Chair Walsh and myself will just present this. It's a Montgomery County delegation bill, and it provided. We don't have a delegation letter yet, but we're working on it, and for Senator Lee as well. So essentially, what it does is allows Montgomery County to decrease the minimum speed limit to 15 miles per hour. So may decrease the maximum speed limit rather to not less than 15 miles per hour on a highway only after performing an engineering study. Some Calvert County has a similar exception, and I think one other municipality or one other county has a similar exception in the statute. We also have an amendment under consideration from the city of Tacoma Park that just says Montgomery County and the municipalities that are located within the county. Again, this bill is still within our delegation. We do not have a delegation letter yet, so I'll keep you all posted. And with that, that'll conclude the hearing for House Bill 562 and the hearings for the day. All right, what time is it? We are at 3 o'clock. Let us meet at 3:45 for voting. That'll get us out at 5:45. About 15. Is that enough time for folks to get something to eat? We'll make sure we order things, make sure you get something to eat before our floor session at 6. So let's do 3:45 down in the hearing room. Excellent.